All right, good morning, everyone. This is the state all-purpose calendar in the state court of Fulton County, Georgia. I'm Judge Melanie Williams. At this calendar today, on June the 2nd, 2026, we will take pleas, arraign cases, and address other matters as necessary. All defendants, please be advised you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to counsel today. As you can see, I'm conducting this hearing by video. I am not there in person with you. That means any member of the public can log on and watch this proceeding. When I ask if you understand your rights, that is what I am referring to. Who do we have first?
Good morning, Your Honor.
Good morning.
Coming up is position 6, Ms. Caulfield.
All right, I have that this is a negotiated plea. Is that correct, Mr. Haddad?
It is, Judge.
All right, Ms. Cofield, your case is 26 CR 003165A. In this case, you're charged with simple battery and criminal trespass. Ms. Tucker, can I please have the state's recommendation?
Yes, Judge. On the simple battery, it's going to be 12 months to serve 60 days, credit for time served, balance probated, to complete the MHET, complete 12 weeks of anger management, and have no further contact with Suzette Weaver. On the criminal trespass, it'll be 12 months to serve 60 days, credit for time served, balance probated, 40 hours community service, and to stay away from 234 Memorial Drive in Atlanta.
All right, is Ms. Weaver on this Zoom conference and wishes to make a statement? Hearing none, Mr. Haddad, was that your understanding you so stipulate?
It is, Judge. I would ask the court to consider waiving the first 2 months of probation fees. According to my calculations, she's going to have about 13 more days in custody before she's released, and she'll have to report to probation judge. Anger management there's a cost associated with each class, so that's the reason for my request. But other than that, I would ask the court to follow the negotiated plea.
All right, 1 second, Ms. Tucker. What is this defendant's history?
One moment. Does pretrial have it?
Um, I was hoping that you did.
Okay, I've got it in 2 seconds.
Okay. I just want to confirm it in light of the quest for the evaluation. Ms. Haddad, if we go forward, I just want to check some things. Um,
Yes, Judge.
Yes,
I'll
okay.
waive 1 month of fees. Go ahead, Ms. Tucker.
So she's got 10 total cycles. Uh, last arrest 4/26, obstruction. February 26, criminal trespass. September 25, criminal trespass. Probation violation in August 24. Criminal trespass August 24. Probation violation February 24. Probation violation September 22. Aggravated assault first offender in February 22. Simple battery family violence null pros 2019.
Okay. All right. We'll move forward with the plea at this time. Thank you, Ms. Tucker, for that. I appreciate it. And again, I'm waiving only 1 month of fees. All right, Ms. Cofield, please raise your right hand if you wish to take a plea. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes.
All right, you can put
Yes,
your
Judge.
hand down. All right, you can put your hand down. Thank you. Are you under the influence of any drugs or alcohol that affect your ability to understand this plea at this time?
No, ma'am. No, no, Judge.
All right, thank you. And you are fully satisfied with your attorney's representation?
Yes.
And you understand that you're giving up your right to trial today?
Yes.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes.
And you understand that you are taking a guilty plea that may affect other aspects of your life, such as probation, employment, immigration, and other matters? Basically, what I'm saying is if you take a plea, it can affect other things. Do you understand that? Did your attorney fully explain to you the implications of taking a plea today?
I actually was just going through the motions, but I actually have reason of doubt because I was
Okay.
assaulted from.
Judge,
So
it sounds
we're
like you're
not,
not guilty. We'll just
yeah,
clear
we're
not
not
guilty.
gonna take this plea today.
All right.
All right, so we're
I
gonna
thought I
wait.
was going to be. I thought I was going to plead. Can I say something?
I don't think you should, but what do you want to say very briefly and let your attorney
I
guide
thought I
you?
was gonna. I
Go
thought I was
ahead.
gonna plead. Not. I thought I was gonna plead guilty. I thought I was gonna plead guilty and get 13 days and get probation and leave.
Yeah, Your Honor, I think
I think we need to I think we're waiving arraignment, Mr. Haddad.
that's fine.
All right, we're not gonna take this plea today, Ms. Cofield. Your attorney will be in touch with you to further discuss the case, okay?
Yes.
All right, take care.
Next is position 57, Mr. Yates.
All right, Mr. Yates, is his attorney on?
Yes, I'm here. I just
All
finished
right.
another quarter. Good morning.
Good morning. And what is the announcement for Mr. Yates today?
Well, I think I need to pre-try it with the prosecutor and also find out why there's a hold on him.
Okay, Ms. Tucker, has there been an offer sent over to Mr. Johnson?
Not to Mr. Johnson. There is an offer. I can send it to him in the chat, or would you rather me email it to you?
Either, it doesn't matter.
Okay, I will send it in the chat in just one moment. I'm checking one thing.
And I guess the question too was, what is the hold, Ms. Tucker?
Yes, that's what I'm checking.
Okay, thank you. And Mr. Howard, if you see the hold too, go ahead, Ms. Tucker.
I think just a possession of cocaine felony. He's got a $30,000 bond on that. There was a probation violation, but that's been dismissed. And so he's served 117 days on this case.
Okay, and he's got what's his current bond? Or Ms. Lewis, can you tell me what his current bond is?
Yes, ma'am. This case for the battery is a $10,000 surety. And like I said, on his other case, like she said, he's serving 6 months on a felony charge right now.
Okay, so he has a bond on this. No,
I did the 6 months already.
don't say anything, sir. Don't say anything. Let your attorney's here to help you, okay? So, Mrs. Johnson, it seems like he has bonds on both of these cases, and there is an offer that Ms. Tucker has. Do you need to speak to your client?
I haven't gotten an offer yet.
I'm sending it right now.
And then I will need to speak to my client. Sure.
Is there a phone at ACDC?
Yes, Your Honor, I will need his phone number so I can call him.
Okay, and Mr. Johnson, could you put that in the chat to ACDC as well?
Sure.
I need to know how many cases I got.
Okay, calm down. You will talk to him. Calm
Yeah.
down.
Judge
Yeah,
Williams,
please don't talk out of turn.
Judge Williams, according to the booking screen, the jail has him time served on the felony case on May 29th to 26th, so that
So
case
that's
is already done.
closed.
Yeah, so only thing
The
is,
only case he
this
has.
holding has is the battery with the $10,000.
So this is the only case he has at this time. Okay, so Mr. Johnson, did you hear that announcement? This is the only case holding him. It looks like the other case is closed, so he may not have a hold.
Great. That's what we want to hear.
All right, so we're gonna keep going if we can. Ms. Tucker, you've already sent that offer over.
Yes.
And then Mr. Johnson, if you could go ahead and call your client, we will keep moving for a moment.
I'm looking, I don't sit. Hold on. But
I'm sorry, say that again.
the offer would have come, I'm not seeing it in the chat.
I sent it directly to you. It's gonna be time served for the jail time, 12 weeks of anger management, 80 hours community service, no further contact with Denisha Towns, and to stay away from 499 Northside Circle.
Okay. Let me talk to my client.
Okay, I'm gonna call you right now. Next, your Honor, is position 55, Miss Weaver.
Okay, I have it.
Yeah,
Okay.
Your Honor, that's gonna be a plea, Judge. And also, I believe Ms. Tucker will clarify it's gonna be a no further violent contact. Ms. Weaver also has another case that we're gonna try and resolve. Is that right, Ms. Tucker? And I can give the case number.
So it's a global offer.
It is, Judge. It should be, I believe.
All right, I need that other case number.
Your Honor, the other case number is 26 CR 003330G. And
That's the one. That's the one on this calendar.
No,
What's
I'm
the
sorry.
other one?
It's 25 CR 004281G.
And what's she charged with in that case?
Your Honor, that case is it's the same,
Simple-
involved in the same
simple
alleged
battery, family
victim,
violence.
Judge.
Okay.
I'm sorry, Ms. Lewis.
I'm just letting you know the charge was simple battery, family violence on that case, Judge.
And it involves the same alleged victim, Judge.
Okay. And what's the relationship to that alleged victim?
Your Honor, they have a child together. I'm sorry, I've misplaced somehow my notes. I'm trying to remember. I believe the parties are married, but let me just double check, Judge.
Okay. All right. So Ms. Weaver, you have two cases that we're gonna see if we can resolve today. 26 CR 003330G, in which you're charged with battery, giving false name and terroristic threats. You also have a simple battery case, 25 CR 004281G. Do you understand your rights today, Ms. Weaver?
Yes, ma'am.
All right, and Ms. Tucker, so the offer would have resolved both cases and there will be no further violent contact with the alleged victim?
Yes, Judge, would you like to offer for position 55 first?
Yes, please.
Okay, so on count 1, it's gonna be time served. Count 2 is time served. And count 3, the battery is 12 months probation to with 60 days to serve, credit for times whatever time she's already served, to complete the family violence intervention program, have no further violent contact with Antavius Henderson, and to stay away from 630 Center Hill Ave.
So the stay away would still be in place despite the no further violent contact?
No, I'm sorry. We did amend it. So no further violent contact, no stay away.
Okay, and she would have additional time to serve on that battery?
No, Judge, I apologize. As of today, it'll be 30 days. This case started out as a felony. before it was transferred. That's why she ended up being in custody a lot more than the typical SAP timeline from SCA to SAP, Judge.
Okay, and on the, thank you, Mr. Haddad. On the second case, what was the recommendation, Ms. Tucker?
That's simple battery. It's going to be 12 months to serve 60 days, credit for time served, all concurrent with the Family Violence Intervention Program, with 40 hours community service and no further violent contact with Antavius Henderson.
Okay,
Your
so
Honor, may I say something?
I don't think you should. I really don't. Hold 1 second. Mr. Haddad, that was your understanding of the offer?
It is, Judge.
And do
And we
you so,
stipulate.
and you stipulate, okay. Ms. Weaver, do you wish to take a plea today?
Yes, ma'am.
Okay. What was your question? Be very careful because the state is listening. What is your question?
I've been living there for 11 years, so and then he also, has no, recourse to it, so I was just stating that.
Okay, so do you want to take a plea and close the case today, or do you wish to proceed to trial, Ms. Weaver? You want to
Yes,
take,
I want, yeah.
I'm sorry, the
I
line
just-
went
that's
out for a second. You want to do what?
I'm sorry. Yes,
The
ma'am,
line
I
went out
do,
for
I
a
just
second.
wanted to let. Okay, yes, ma'am.
Okay, and you wanted to tell me that what was the other part that you said you wanted to tell me?
Oh, I just lived there. That's how I was just saying that I just lived there at 637 here. That's my house.
Okay, all right.
That-
All right, please
that's it.
raise your right hand, Ms. Weaver. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge?
Yes, ma'am.
All right, thank you so much. You can put your hand down. All right? Am I going in and out? Are you all able to hear me? Ms. Tucker and
Yes.
Ms.
We can hear you,
Judge. Okay, I'm making sure the internet's not going in and out. All right, are you under the influence of any drugs or alcohol that would affect your ability to understand this proceeding today, Ms. Weaver?
What she said?
Do you understand the
Do you
proceeding?
understand
Yes.
what's happening today? What are we doing today, Ms. Weaver?
We're in court.
And where are
And
you
I'm taking
taking
my
a,
plea.
all right, and that's what you want to do?
Yes, ma'am.
And you understand you're giving up your right to trial by judge or by jury?
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you understand that you are giving up your right to have, I'm sorry, are you satisfied with Mr. Haddad's representation?
Yes.
All right, and do you fully understand the requirements, including the fact that you'll have to complete community service, take a family violence intervention program class, that you've served some time in the Fulton County Jail, and you're to have no further violent contact with Mr. Henderson? Do you understand all of that?
Yes, ma'am.
And you understand that taking a guilty plea can affect other aspects of your life, such as probation, immigration, employment, or other matters we may not be able to anticipate?
Yes, ma'am.
All right, as to the charges I previously listed associated with your cases, Ms. Weaver, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from the state or from the defense?
No, Judge.
All right, Ms. Weaver, that concludes your case. Best of luck to you, okay?
Thank you.
Can you repeat, are they gonna, when you don't say nothing about probation, they're just gonna remain on probation?
I'm sorry, I couldn't hear you, Ms. Lewis.
I guess for my records, for court and I don't hear nothing about probation being non-reporting or suspended, they're just gonna remain on probation?
Right, if there's no affirmative ask, that's what I'm assuming.
Okay.
Okay, all right, thank you. All right, we're back to Mr. Yates. Mr. Johnson, you have an announcement?
Yes, Judge, he's gonna reject the plea at this time. So we
Okay.
just like to go ahead and confirm the bond amount again, and we'll have someone pay it.
Okay, and has this case been arraigned, Ms. Lewis?
Mr. Johnson filed a waiver of arraignment.
Okay, wonderful. All right, so the case will be reset for the notice for trial. Mr. Yates, your attorney has some additional development to do between now and then, and he will be in touch with you, I'm sure. All right?
And can I just confirm that bond amount again, please?
$10,000 is what we have.
Okay, thank you.
All right. Best of luck to you. And does that include your business, Mr. Johnson?
It does, Judge. May I
Take
please be
care.
excused?
Yes, you may. Take care. Have a wonderful afternoon. Bye-bye.
All right, bye-bye.
Thank you, Your Honor.
All right, take care. Bye-bye. All right, and what attorney is at courtroom 2? I'm sorry, the screen is really small today.
Your Honor, my name is Zachary Judd, attorney with the Public Defender's Office.
Okay, Mr. Judd, I know who you are, just couldn't see. The screen is real little today.
Oh,
Thank you. All right, Mr. Judd. All right, who do we have and what is the announcement?
28, Mr. Hudson.
And what is our announcement for Mr. Hudson? This is the negotiated plea?
Yes, Your Honor. And just to clarify, because there are two Mr. Hudsons on the calendar, this is Mr. Nicholas Hudson. And
Oh, okay, understood. Thank you. Mr. Hudson, your case 26 CR 003238Y, you're charged with giving false information, 2 counts, and not walking on the sidewalk. Do you understand your rights this morning?
yes, ma'am.
All right, thank you so much, Ms. Tucker.
Yes, Judge, on count 1, giving false info, it's going to be 12 months to serve 32 days, credit for time served 16 days, balance probated, to complete the Operation 21 Law and Decision Making course, and to complete 20 hours of community service. On count 2, giving false info, 12 months to serve 32 days, credit for time served 16 days, balance probated, an additional 20 hours of community service, so it'll be 40 total. And then for the pedestrian roadway, that's just time served.
All right, thank you. Mr. Judd, was that your understanding? Do you so stipulate to the 3 elements?
We do so stipulate, Your Honor, and we are just asking that Mr. Hudson be allowed to go either non-reporting or early termination upon completion of the probation.
I'm inclined to allow him to go non-reporting. Any objection, Ms. Tucker?
No objection.
All right, Mr. Hudson, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right, thank you. Put your hand down. You are you satisfied with your attorney's representation today?
Yes, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Are you under the influence of any drugs or alcohol that would affect your ability to understand this proceeding today?
No, ma'am.
And you understand you're giving up your right to trial by judge or by jury?
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you fully understand the requirements, including the community service and class you have to take?
Yes, ma'am.
And you understand that taking a guilty plea can affect other aspects of your life, such as probation, employment, immigration, or matters I may not be able to anticipate?
Yes, ma'am.
All right, as to the charges of giving false information, 2 counts, and not walking on the sidewalk, how do you plead, Mr. Hudson?
Yes.
I accept your guilty plea. Is there anything additional from Ms. Tucker or Mr. Judd?
Nothing from the defense, Your Honor.
Further.
All right, best of luck to you, Mr. Hudson. We don't want to see you back here, all right?
This is my time.
Come on.
All right, that's 29, Mr. Lawson. Oh, Your Honor, I haven't spoken to Mr. Lawson yet. I believe he was just brought down.
Okay, I have need to speak to. Is there another position we could potentially take?
We go to 482, 483, Mr. Richardson.
Okay. All right, Mr. Richardson, this is a negotiated plea, is that correct?
That's correct, Your Honor.
All right, thank you. Mr. Richardson, you have 2 cases today, 26 CR 003191A, and once you're charged with loitering and prowling and criminal trespass. You also have 25 CR 005713A, and once you're charged with criminal trespass. Do you understand your rights? Is that a yes?
Yeah.
All right, thank you. Ms. Tucker?
Yes, Judge. On position 42, the loiter and prowling is going to be 12 months probation with any credit for any time served. To complete the MHET, to stay away from 165 Cortlandt Ave, and to complete 40 hours of community service. Criminal trespass will be 12 months probation concurrent with that MHET. In position 43, the criminal trespass will be 12 months probation consecutive, so he'll have 24 months probation total with an MHET, stay away from all GSU property, and an additional 40 hours of community service.
All right, Mr. Jed, that was your understanding. Do you so stipulate?
We do so stipulate, Your Honor, and we would just ask that Mr. Richardson be allowed to go non-reporting upon completion of the terms of probation.
Okay. I'm not sure. Let me think about, hold on one second. Let me look at one thing.
Yes, Your Honor.
Some things have happened in the past few weeks that make me, when I see MHET, I start looking at things a little more closely. Ms. Tucker, can I have that? Do you have his history? Mr.
Yes,
Howard, do you have his history? Oh, you have it, Ms. Tucker?
I'll pull it up.
Or Mr. Howard, can you give it to me, please? Either one of you, please. I may require him to report the entire term. 42 Richardson.
I've got it.
Okay.
So it is 4 total. His most recent September 25 criminal trespass, May 2022 criminal trespass, and October 2019 criminal trespass.
Okay. All right. I feel confident that he can go non-reporting then. Okay. All right, Mr. Richardson, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol that would affect your ability to understand this proceeding at this time?
No.
Did anyone force you to take a plea?
No.
Did anyone promise you anything in exchange for taking a plea?
No.
And you understand you're giving up your right to trial by judge or jury?
Yes.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yeah.
And you understand the requirements that you have to do community service, and you absolutely have to stay away from that location on Cortlandt Avenue. Do you understand that?
Yeah.
And you understand you can't go back to any area at Georgia State?
Yes.
All right. And you understand that you also are going to have to undergo some evaluations that are very important. Do you understand that, Mr. Richardson?
Yes.
All right. As to the charges previously listed, how do you plead?
True. Yes.
I'm sorry, I could not hear you. How do you plead?
Guilty.
All right, I accept your guilty plea. Is there anything additional from state or defense?
No, Your Honor.
All right. Best of luck to you, Mr. Richardson. Please do not go back to those locations.
And if we go 31, Mr. Mack. Mack.
Well, I have need to speak to. Is there an announcement?
Yes, Your Honor. Mr. Joshua Mack is pleading guilty today.
All right. All right, Mr. Mack, your case is 26 CR 003243E. You're charged with disorderly conduct and criminal trespass. You understand your rights?
Yes.
All right, Ms. Tucker.
Yes, Judge. On the disorderly conduct, it's going to be 12 months to serve 32 days, credit for time served 16 days, probated. To complete the alcohol, drug evaluation, and any recommended treatment, complete 8 hours of anger management, and to stay away from the Central Library in Atlanta. That's 1 Margaret Mitchell Square in Atlanta. On the criminal trespass, it'll be time served with a stay away from the Central Library.
Okay, that was your understanding, Mr. Jett, and you so stipulate to the 3 elements?
It is, Your Honor, and we do so stipulate.
All right, Mr. Mack, if you wish to take a plea, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol that would affect your ability to understand the proceeding today?
No.
Did anyone force you to take a plea?
No.
Did anyone promise you anything in exchange for taking the plea?
No.
And you understand taking the plea, you're giving up your right to trial by judge or jury,
Yes.
and you're giving up your right to have the state prove these charges against you beyond a reasonable doubt.
Yes.
And you understand that you have requirements, that you should not have additional time in the Fulton County Jail. However, you're gonna undergo some important evaluations. You're to take 8 hours of anchor management, and you absolutely need to stay away from the central library. Do you understand that?
Yes.
And you feel fully satisfied with your attorney's representation in this case?
Yes.
As to the charges of disorderly conduct and criminal trespass, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional?
None from the defense, Your Honor.
All right. Best of luck to you, sir. That concludes this case.
Thank you, Your Honor.
Thank you.
And then we have 34, 35, and 36, Mr. Moore.
And our announcement, is this a plea?
Yes, Your Honor, Mr. Moore will be pleading guilty on the criminal trespass, and we are pleading not guilty on the obstruction.
Okay, so position 35. And what happens to the null prize, Ms. Tucker, in light of a partial plea? I'm sorry, not the null prize, the FTA. You're muted.
Sorry, my dog was barking, so I muted
That's
it.
okay.
I'm pretty sure that the FTA was on the criminal trespass, so I'll still null pros the FTA.
Okay. And we're gonna waive arraignment on number 35. Okay. All right. Mr. Moore, you have technically three cases today. 25 CR 007629F, in which you're charged with criminal trespass. You also have 26 CR 002978F, in which you're charged with obstruction. We will not be addressing that case today. You also have an FTA pertaining to the criminal trespass. Ms. Tucker?
Yes, Judge. On the criminal trespass, it'll be 12 months to serve 14 days, credit for time served 14 days, balance suspended with a stay away from the Walmart at 970 Mansell Road. And in consideration of the plea, we will be null prosing position 36.
Okay, understood. All right, thank you, Mr. Judge. That was your understanding,
It is, Your Honor.
and you so stipulate to the three elements.
We do, Your Honor.
All right, Mr. Moore, if you wish to take a plea, please raise your right hand. You swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes.
All right, thank you. Are you under the influence of any drugs or alcohol that would affect your ability to understand the proceeding?
No.
Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange for taking a plea?
No.
And you understand you're giving up your right to trial by judge or jury today?
Yes.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes.
And you fully understand the requirements that you need to stay away from that Walmart?
Yes.
But otherwise, the time you serve in Fulton County Jail should close this matter. You understand that taking a guilty plea can affect other aspects of your life, such as probation, employment, or immigration?
Yes.
All right, as to the charge of criminal trespass, how do you plead, Mr. Moore?
Guilty.
I accept your guilty plea. Is there anything additional from State of Defense?
No, Your Honor.
All right, and best of luck to you, Mr. Moore. That concludes this case, but you have one other matter on this particular calendar that your attorney is going to address later. All right?
That's one.
38, 39, Mr. Pepperlaw next.
All right, and what's the announcement there?
Your
I'm
Honor,
sorry.
I'm sorry.
Go ahead, Mr. Judge. I cut you out for a second. I'm ready.
Your Honor, Mr. Pavlon would like to see if we can address bond, and if we are unable to modify bond, then he would be willing to enter into a plea.
I don't think that's quite okay. What is his current bond?
His current bond, I believe, is a cash only. Was it 1,000? 6,000 cash only.
Okay, and who said, I'm sorry, was that, let me take a look at that. Hold on. What is this defendant's history if there's a cash on this DUI? Let's
Yes,
see.
Judge. He's got 14 cycles, most recently FTA, an FTA in 2022, DUI in 2022, so subsequent to this. Or yes, subsequent DUI, a DUI in 2017, another FTA, lots of FTAs, battery family violence from 2015.
So the DUIs that you see, Ms. Tucker, are subsequent to this 2017 case?
So this is the 2017 DUI?
This
Yes.
is the 2017, so he
Then
got
he's
DUIs
got
after
one,
this.
correct, one DUI after this. And I mean, he's failed to appear multiple times. He's been arrested at least on another failed to appear in 2022. This case has been going on almost 10 years now, so I would ask that the bond remain as set.
Hold on. Ms. Lewis, can you look at your chat, please? All right, Mr. Jed, I'll hear your arguments for bond while I look up one thing. Please proceed, Mr. Jed.
And just for the record, our internet connection went out in the middle of what Ms. Tucker was saying, so we were unable to hear or see anything for a while.
Oh, okay.
But we are aware.
The reason he's got the cash bond is because he failed to appear. So it wasn't, he didn't show up to court and the bond, the surety turned into cash is what happened here. So the case technically made bond on the actual case. It's the FTA that has turned to cash. And I'm sorry, Ms. Tucker, you said that he had FTA'd how many times?
It was at least 3, but I want to make sure I get it exactly correct. So he FTA'd obviously when he was arrested for this. There was an FTA in 2022, a probation violation in 2018, an FTA in 2016, and a probation violation 2015. Another FTA in 2014. So
Okay.
consistently FTA, throughout.
Okay. I just wanted to make sure FTA there's of course no excuse for that, but I wanted to make sure that the cash bond wasn't based on a DUI history before we even move forward. Mr. Judd, is there a reasonable explanation for the lengthy number of FTAs?
Your Honor, we are able to explain at least one FTA, a recent one out of Dooley County. His mother had thought that had been handled, and so there was a miscommunication there between him and his mother as far as the court appearance. We do not have really an explanation for this FTA here. Mr. Pavillon says that he was not at that address, the address that it was sent to.
Okay.
I mean, in response, it's the defendant's duty to update his address. This case has been pending since 2017, so he knows it's out there.
Okay. So what I will do is I'm gonna convert it back to the $6,000 surety, if that's what he wishes to do. But he must update his address immediately, and he will not get another pass.
Yes, Your Honor.
Okay. All right, so we'll convert. Please submit that order, Mr. Jadward. It's just going to be a conversion from the cash to a surety.
As soon as I get back to my office and my computer, I will do that, Your Honor.
Understood.
And that,
All right,
and that is on the FTA, Your Honor.
correct.
So yeah, I want to do the form, those in case I do that. Just.
All right, I believe that, is there anything else you wish to address?
Not Mr. Pavillon, Your Honor.
All right. All right, who do we have next? Good luck, sir. Best of luck to you, sir.
40, Mr. Pugh.
I'm sorry, Judge, before we start on position 38, what is Mr. PD Judge gonna do? He's gonna waive the arraignment on that case?
Well, isn't technically he's made bond on that. It should be the only the FTA holding him in, correct?
No, he's in jail for the FTA, which y'all getting ready to convert to a $6,000 surety. So I'm just
Right.
trying to figure out what will we doing with 38? Is this gonna be reset further notice, or if he doesn't post that bond, what we doing?
That'll just be a waiver on 38.
Okay, that's what I need to. Thank you.
Well,
He
okay.
has failed to appear from every plea and arraignment.
Yeah,
He
I
failed to
see that.
appear in January 2020, in February 2023, so I think he still needs to be arraigned.
We'll waive arraignment.
We'll waive arraignment.
Okay, that's fine. All right, who do we have next?
Number 40, Mr. Pugh.
Your
All
Honor,
right.
my understanding that Mr. Pugh was a possible DA transfer, so there was no offer on Mr. Pugh.
Is there still no offer?
That is correct.
All right, so how long has it been, have we been waiting for the DA to take it or not take it?
Let me check.
Because if it's, at some point, what's his current bond?
What
Ms. Lewis,
position are we on? I'm sorry.
number 40, what's Mr. Pugh's current bond?
I believe it's 1,000, Your Honor.
It's $1,000 surety?
I believe that's correct, Your Honor.
Okay. So if there's no offer and they haven't taken it over, I want to see how many times has this been? Let's see, when he
It's
was,
been reset from SAP twice.
okay,
And my response is just I don't feel we don't have jurisdiction to make an offer in this case. It should be a felony shoplifting recidivist by statute. So I can't
but if
make
they
an
don't
offer.
take it though, Ms. Tucker, we, it's been in limbo for a long time. We're gonna reset one more time, SAP. I strongly suggest your office make an offer because, I mean, honestly, from what we've seen, the DA's office is not taking these.
Right. And the defendant can always go non-negotiated. So we could always take a plea today. But it's the state's position on the record that we cannot make an offer.
So, right, but your offer would essentially be, time served 1 year. So I'm gonna reset it one time and ask you to look at it again, since in light of the fact that there's no offer at this time. And then, your offer is technically 1 year to serve. Do you want to present a different offer, Mr. Pugh, or do you want to reset 1 week with my instructions to look at to the state to look at this again, in light of the fact that the DA is not likely to take this?
Your Honor, if I could have a minute to speak with Mr. Pugh, and just to clarify, that was 1 year to serve a full year.
I'm assuming if there's no offer, that's typically what it
Yeah.
is, if we serve a full year.
Correct.
Your Honor, if I could just have a moment to speak with Mr. Pugh.
All right.
Your Honor, Mr. Pugh would like to see if we can get that one last reset and see if we can get a proper offer from the state.
Okay, so we're gonna reset to next Tuesday, 6/9 SAP. And I'm gonna suggest, Ms. Tucker, that your office still look at it, because even if you go non-negotiated, it would be better for your office to consider some conditions, I think.
Okay.
Because it's unlikely, I think. I haven't seen them take a shoplifting lately. All right, Mr. Pugh, we'll see you next week. Best of luck to you. You do have $1,000 bond.
No, I don't have that on.
All right, let's have 44, Mr. Seaborn.
I'm not sure. Mr. Seaborn. Yeah.
All right, and the announcement for Mr. Seaborn, I don't have an announcement here.
Your Honor, Mr. Seaborn is going to be a negotiated guilty plea.
Okay, thank you. Mr. Seaborn, your case is 26 CR 003154G. You're charged with possession of a drug-related object and criminal trespass. You understand your rights?
Yeah.
All right, thank you. Ms. Tucker?
Yes, Judge. On count one, criminal trespass is going to be 12 months to serve 60 days, credit for time served, balance suspended with a stay away from 245 Memorial Street or something. I'm sorry. It's the BP gas station at 245 Memorial. And for count two, it'll be time served.
And so it's not intended for this to be a time served plea at this time?
It's 60 days to serve. I'm not sure how many days he's served.
Okay, so he may have some additional time to serve. Mr. Jed, was that your understanding of the offer, and do you so stipulate to the 3 elements?
Yes, Your Honor, we do. And by my calculations, it's about 2 weeks left to serve.
Okay, and your client wishes to move forward and take the plea?
Yes, Your Honor. That's
All right,
good.
Mr. Seaborn, please raise your right hand if you wish to take this plea today.
About 2 weeks to serve.
Do you wish to take a plea, Mr. Seaborn? They're optional. You do not have to take one if you don't wish to.
2 more weeks, Judge. I've been here on 30 days.
I understand, but if you take a plea, you would still have 2 weeks. It sounds like you don't wish to take this plea.
Yeah, I guess I have to. Shit, you making me.
No, we're not making you. We're not taking this plea today.
Yeah, ma'am, I'm taking it.
No, it don't seem like you wanted to. I don't feel comfortable.
I take it, ma'am.
Okay, so Mr. Seaborn, what you just said to me was that you were being forced to take a plea. If you feel coerced or forced, I cannot take that plea.
Ma'am, I'm taking the plea, ma'am.
This is okay. Why don't you confer with your attorney very quickly? Put me on mute and make sure that this is what he wants to do.
Yes, and just for the record, he has 12 more days to serve.
Okay. All right, we're still muted if you all are finished discussing, but if not, all right.
That's me, Your Honor.
I'm sorry. All right, so where do we stand?
Your Honor, Mr. Seaborn would like to go forward with a negotiated guilty plea.
All right, and you're sure that that's what you wish to do, Mr. Seaborn? No one is forcing you. Please have to be 100% voluntary. Do you wish to take a plea today?
Yes, ma'am.
All right, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol that would affect your ability to understand this proceeding today? I'm sorry, speak very loudly. There's some noise in the background.
I said, no, ma'am.
Thank you so much. Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange?
No, ma'am.
And you understand that taking a guilty plea, you're giving up your right to trial by judge or jury?
You're not going to have a trial on this.
You're giving up your right to trial. You understand that? Is that a yes?
Yes.
All right. And you understand that you're giving up the right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you understand the requirements as explained to you by your attorney? All right. As to the charges of criminal trespass and possession and use of a drug-related object, how do you plead, Mr. Seaborn?
Guilty.
I accept your guilty plea. Is there anything additional from the state or from the defense?
Your Honor, we would just ask that his probation be non-report.
All right, I have no objection in one non-report and once he,
What is he going on probation for? I thought it was a balance
Yeah,
suspended.
it
Oh,
is.
it's
oh,
balance
it should be balance
It's
suspended, yeah.
balance
Good,
suspended.
never mind that.
He just need to have a stay away.
Yeah, it's balance suspended. All right, so that's taken care of. All right, best of luck to you, Mr. Seaborn.
All right, next we got 53, Mr. Square.
All right, Mr. Square, this is a negotiated plea.
That's correct, Your Honor.
Mrs. Square, your case is 26 CR 003224C. You're charged with criminal trespass. You understand your rights?
Ma'am.
Thank you, Ms. Tucker.
Yes, Judge. He's pleading to criminal trespass. It'll be 12 months to serve 30 days, credit for time served, balance suspended, and to stay away from MARTA in accordance with his permanent ban.
Okay, and he would have some additional time to serve, I'm assuming, Mr. Judge?
I don't believe so, Your Honor.
Yeah, I don't believe so.
He should be done.
Okay, all right. Do you stipulate to the three elements and that was your understanding?
We do, Your Honor.
All right, thank you, Mr. Judge. If you wish to take a plea, please raise your right hand. Do you swear or affirm that the testimony you give today will be the truth to the best of your knowledge?
Yes, ma'am.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol that would affect your ability to understand this proceeding today?
No, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Anyone promise you anything in exchange?
No, ma'am.
And you understand that taking a guilty plea, you're giving up your right to trial by judge or jury.
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt.
Yes, ma'am.
And you understand the requirements that you cannot go back to MARTA.
Yes, ma'am.
And you're satisfied with Mr. Judd's representation.
Yes, ma'am.
All right. As to the charge of criminal trespass, how do you plead?
Yep.
I'm sorry, say that again?
Yep.
I accept your guilty plea at this time. Is there anything additional from the state or from the defense?
No, ma'am.
No, Your Honor.
All right. Best of luck to you, sir. That concludes your case at this time.
Thank you, Your Honor.
And then we got 54, Mr. Turner.
All right. I don't have an announcement. Is that a negotiated plea?
It is, Your Honor.
All right. Mr. Turner, your case is 26 CR 003179A, in which you're charged with theft by taking. You understand your rights?
Yes, ma'am.
Ms. Tucker?
Yes, Judge. On count one, theft by taking, that's going to be 12 months probation with a credit for any time served. To complete the anti-theft course, complete 40 hours of community service, and have no further contact with Edeg Boyego Adu. Count two will be time served.
All right. Is Aded Boyega Adu present? Wishes to make a statement? Hearing none, Mr. Judge, is that your understanding of the offer, and do you so stipulate?
We do, Your Honor, and that is our understanding.
All right, thank you. Mr. Turner, please raise your right hand if you wish to take a plea. Are you under the influence of any drugs or alcohol that would affect your ability to understand this proceeding?
No, Your Honor.
Did anyone promise, you can put your hand down, thank you so much. Did anyone promise you anything in exchange for taking a plea?
No.
Did anyone force you to take a plea?
No.
Are you satisfied with your attorney's representation?
Absolutely.
And you understand the requirements of the sentence, including the fact that you'll need to take an anti-theft course. You're going to do 40 hours of community service, and you're to have no contact with Mr. Adu. You understand all of that?
Yes, Your Honor.
And you fully understand that taking a guilty plea can affect other aspects of your life, such as probation, employment, immigration, or other things your attorney or I may not be able to anticipate?
Yes, Your Honor.
All right, as to the charge of theft by taking, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from the state or from the defense?
Yes, Your Honor. We would just ask that upon the completion of his community service and his anti-theft class, that he would be allowed to have his probation early terminated.
I'll allow him to go non-reporting, okay?
Oh, I have one more question. You
Why
know,
don't you ask your attorney and let him ask me? Actually, let me look at one thing really quick. It can terminate. Any objection, Ms. Tucker, to the termination?
No objection.
All right, and the question or concern, Mr. Judge?
No questions or concerns, Your Honor. I believe he
All
was
right.
just looking at the price of the class, and yes, that's correct.
All right. Best of luck to you, sir. That concludes this case, okay?
Thank you. Thank you, Your Honor.
if we got 56, Mr. Woodlow.
All right, I have that this is a negotiated plea.
Yes, Your Honor.
Mr. Woodruff, your case is 26 CR 003187L. You're charged with criminal trespass. You understand your rights?
Yes, I do.
All right, thank you, Ms. Tucker.
Yes, Judge, this is going to be time served with a stay away from all GSU property.
All right, thank you. Mr. Judd, that was your understanding. You so stipulate?
That is our understanding. We do so stipulate, Your Honor.
All right, thank you. Mr. Woodruff, please raise your right hand if you wish to take a plea. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No,
Did anyone force you to take a plea today?
no,
Did anyone promise you anything in exchange for taking a plea?
no.
And you understand that taking the plea, you're giving up your right to trial by judge and jury,
You have to answer verbally.
Yes.
and you're giving up your right to have the state prove these charges against you beyond a reasonable doubt.
Yes.
And you understand that taking a guilty plea can affect other aspects of your life, such as probation, employment, or immigration, or things your attorney or I may not be able to anticipate.
Yes.
And you're satisfied with your attorney's representation?
Yes.
All right, as to the charge of criminal trespass, how do you plead?
Yes.
I accept your guilty plea. Is there anything additional from the state of defense?
No.
No, Your Honor.
All right, best of luck to you, Mr. Woodruff. That concludes your case today.
Thank you, Your Honor.
Case 58, Mr. Young.
All right, I have the addition of the plea as well.
It is, Your Honor.
All right, Mr. Young, you have a charge I will not sound today in 26 CR 003009E. All right, Ms. Tucker.
Yes, Judge, it's going to be 12 months probation, credit for any time served, to complete the SD eval and any treatment, and to stay away from MARTA.
Okay. That was your understanding, Mr. Judd, and you so stipulate?
It is, Your Honor, and we do so stipulate.
All right, Mr. Young, if you wish to take a plea, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, Your Honor.
All right, thank you. Are you under the influence of any drugs or alcohol that would affect your ability to understand this proceeding?
No.
Did anyone force you to take a guilty plea today?
No.
Did anyone promise you anything in exchange?
No.
You understand that taking a guilty plea, you're giving up your right to trial by judge or by jury,
Yes, Your Honor.
and you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes.
And you understand that taking a guilty plea may affect other aspects of your life, such as probation, employment, immigration, or other matters your attorney and I may not be able to anticipate?
Yes.
And you fully understand the requirements, including the evaluation that you'll have to undergo, and the
Yes.
fact that you need to stay away from MARTA?
Yes.
All right, as to the charge associated with this case, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional, Ms. Tucker or Mr. Jackson?
Yes, Your Honor. Mr. Brian Young does live in Florida. We do have that valid address, so we're asking that probation be phoned in.
I'm sorry, you asking that probation be what?
Phone in report.
All right, I will allow him to appear by phone.
Thank you, Your Honor.
All right, best of luck to you, sir. Who do we have next?
Number 5, Mr. Allen.
All right, I have that this is a negotiated plea.
That's correct, Judge.
All right. Mr. Allen, good morning. Your case is 26 CR 003157D. You're charged with theft by shoplifting. You understand your rights?
Yeah.
All right, Ms. Tucker.
Yes, Judge. It's going to be 12 months to serve 60 days. Credit for any time he's already served. To complete balance probated. To complete the anti-theft course. Pay a $250 fine. And to stay away from the Family Dollar at 2925 Headland Drive in East Point.
All right. Was that your understanding, Mr. Judd, and do you so stipulate?
Yes, Your Honor, we do stipulate, and that is our understanding. We would just ask to convert the
Oh,
fine.
I'm sorry, Mr. White.
No worries. We would ask to convert the fine to 25 hours community service and ask that his probation terminate or go non-reporting once he completes his requirements. He does have another 12 days to do in jail.
All right. I will convert the fine to community service and he can go non-reporting once he's completed. Any objection, Ms. Tucker?
No objection.
All right, Mr. Allen, please raise your right hand if you wish to take a plea today. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Wow.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
I'm
Did anyone force you to take a plea?
out.
Did anyone promise you anything in exchange?
No.
And you understand that taking a guilty plea, you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Ma'am.
And you understand further the requirements of the sentence, including the community service, that you have some additional time to serve and that you are going to complete an anti-theft course. Do you fully understand all those requirements as explained by Mr. White?
Yes, I do.
And you're satisfied with Mr. White's representation?
Yes, I am.
As to the charge of theft by shoplifting, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from state or defense?
Nothing further from defense, Your Honor.
All right, best of luck to you, sir. That case is now closed.
Next one, number 7, Mr. Colello.
I don't have an announcement for that, Mr. White.
It's a negotiated plea, Judge.
All
I'm
right,
not- Just so you know, anything that doesn't have an announcement that I'm bringing up will be a plea this morning.
understood. Thank you. Mr. Colello, your case is 26 CR 003063G. You're charged with simple battery. You understand your rights?
Yes, ma'am.
All right, thank you. Ms. Tucker, I am going to ask you for the history.
Yes, 1 second. So he has history out of New York, larceny 2017, history out of South Carolina, drinking 2013. And then in Georgia, he's got 13 cycles. Most recently, a criminal trespass, August 25, entering auto conviction, October 24, probation violation, July 23, failure to appear, March 23, obstruction and robbery, First Offender Act in June 21, criminal trespass, August 19, theft by taking, 2019. Would you like me to keep going?
No,
Criminal
that's
trespass
good.
conviction? Okay.
That's good. That's good. I
Yes.
think I have the idea. And he has some additional time to serve under this sentence.
Yes.
Okay.
Yeah, so
Okay.
the state's recommended offer would be 12 months to serve 64 days, credit for time served, balance probated, to complete 12 weeks of anger management, to complete an MHET, to have no further contact with Travis Hood, and to complete 80 hours of community service.
All right, is Travis Hood present, wishes to make a statement? Okay. All right, Mr. White, was that your understanding of the offer, and do you so stipulate?
That was our understanding, Judge, and we do stipulate for the purpose of the plea. Again, we would just ask that the probation go non-reporting once he completes all of his requirements and waive 2 months of his probation fees. He has no income at this point.
All right, I will wait the 2 months and he can go non-reporting once he's completed. All right, Mr. Colello, if you wish to take a plea, please raise your right hand. Please are voluntary. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol that would affect your ability to understand this proceeding today?
No, ma'am.
Did anyone force you to take a guilty plea?
No, ma'am.
Did anyone promise you anything in exchange for taking the plea?
No, ma'am.
And you understand that taking a guilty plea, you're giving up your right to trial by judge or jury?
Yes, ma'am.
You're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you fully understand the requirements of the sentence as explained to you by your attorney, including the evaluation, the 80 hours of community service, the additional time you have to serve in the Fulton County Jail, and the fact that you are to have no further violent contact with Mr. Hood. Do you understand all of these things?
Yes, ma'am.
All right, as to the charge of simple battery, how do you plead?
I'm guilty, ma'am.
All right, I accept your guilty plea. Is there anything additional, Mr. White or Ms. Tucker?
Not from us, Judge.
All right, Mr. Colello, best of luck to you. That concludes this case.
Thank you, Your Honor.
Number 9, Mr. Cecil, Mr. Christie, I'm sorry.
All right, Mr. Creasy. Good afternoon. I'm sorry, it's morning still. Your case is 26 CR 003221F. You're charged with simple assault, theft by shoplifting, and obstruction. Do you understand your rights?
Yes, ma'am.
All right, Ms. Tucker.
Yes, Judge. On the simple assault, it's going to be 12 months to serve 30 days, credit for any time served, balance probated, to complete an 8-week anger management, 40 hours community service, and have no further contact with Sarfraz Muhammad. On count 2, theft by shoplifting, that's going to be 12 months. Serve 30 days, credit for time served, balance probated, to complete the anti-theft course and pay a $250 fine, and again have no further contact with Sarfraz Muhammad, and to stay away from the Family Dollar at 3721 Campbellton Road in Atlanta. And on the obstruction, it's going to be 12 months probation concurrent with a $300 fine, or that could be converted to 30 hours community service.
All right, thank you, Mr. White. Do you so stipulate, and that was your understanding?
We do stipulate for the purpose of the plea, Judge. It is our understanding. We it's for the 30 hours of community service versus a $300 fine. 30 hours. I'm sorry, Judge he'll go with the fine. And just ask that the probation go non-reporting once he completes all of his requirements.
All right, he can go non-reporting. All right, sir, please raise your right hand if you wish to take a plea today. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge?
Yes, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time that would affect your ability to understand this proceeding?
No, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand that by taking a guilty plea, you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you fully understand the requirements of the sentence, including the anti-theft course, the fines you'll have to pay, the anger management class, and that you're to have no further contact with Mr. Muhammad?
Yes, ma'am.
All right, I'm sorry, and I'm sounding for Sarfraz Muhammad at this time? All right, as to the charges associated with this case, including simple assault, theft by shoplifting, and obstruction, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from State of Defense?
No, Your
All
Honor.
right. All right, best of luck to you, sir. That concludes this case.
Thank you, Judge.
Defendant number 10, Mr. Dickerson.
All right, Mr. Dickerson, your case is 26CR003168C. You are charged with battery, family violence, and battery. Do you understand your rights today? Is that a yes? All right, thank you so much. Ms. Tucker?
Yes, Judge. The battery family violence is going to merge into the battery. So he's only pleading to battery. That'll be 12 months to serve 60 days, credit for time served, balance probated to complete the 12-week anger management course, 40 hours of community service, have no further contact with Brenda Clopton, and to stay away from 440 Woodlawn Avenue in Atlanta.
Mr. White, that was your understanding, and you so stipulate?
Yes, Judge, and again, we would just ask for his probation to go non-reporting once he completes all of his requirements. He does have an additional 13 days in jail to do.
All right, he can go non-reporting. All right, if you wish to take a plea, Mr. Dickerson, please raise your right hand.
Yes. Raise your right hand.
You wish to take a plea? All right, you raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
I'm trying to understand. You asking me to do community service and do anger management?
Judge.
Correct. Do you wish to take a plea today?
Yes, ma'am.
You sure?
Yeah.
All right, you can put your hand down. Mr. White, you were going to say something?
I was just going to go over the offer with him again if need be.
Okay, sir. Do you wish to speak to your attorney again about what the offer is?
I understand what you're giving me, which is basically that you're anger management and community service.
Okay, if you take the plea today, you would be doing 12. You would have some additional time to serve at the Fulton County Jail. Upon release, you would be doing 12 weeks of anger management, 40 hours of community service. You're to have no contact with Brenda Clopton, and you're going to stay away from the Woodlawn Avenue address. Would you like to speak with your attorney further, or do you wish to take a plea?
I'll take a plea with you, ma'am. It's fast.
Okay. Let's sound for Brenda Clopton. Are you present? Okay, Mr. Dickinson, you indicated, okay, let's just do it again. Please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
No.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol that would affect your ability to understand this proceeding today? Did anyone promise you anything in exchange for taking the plea?
Yeah.
Anybody promise you?
Somebody promised you something?
No, he said, ma'am.
Oh, did anyone promise you anything in exchange for taking a plea?
No, you're telling me community service.
Did anybody offer you?
Okay, did anybody give you something in exchange for taking a plea?
I understand.
So nobody promised you?
Okay, I don't know that we can take this plea today, Mr. White.
Judge, I believe that we can get there. He understood everything we were talking about earlier. I think the question is.
Okay, so what I'm saying is taking a plea is something that you have to want to do. Did anyone give you a gift or any money or make any promises to you in exchange for taking this plea today?
Oh, no, ma'am. No, ma'am.
Okay, did anyone force you to take a plea?
No, ma'am.
And you understand the requirements, including the anger management community service that you would have to complete?
Yes, ma'am.
You're satisfied with Mr. White's representation? And you fully understand that you are giving up your right to trial today?
Yes, ma'am.
Like there'll be no other court dates. You understand that?
No.
All right. As to the charge of battery, Mr. Dickerson, how do you plead? All right. I accept your guilty plea. Is there anything additional, Mr. White or Ms. Tucker?
No, Judge. Thank you.
All right. Best of luck to you, sir.
There we go. All right, next, number 20, Mr. Harris.
All right, Mr. Harris, you're charged with, your case is 26 CR 0031664F. You're charged with simple battery. Do you understand your rights today?
Yes, ma'am.
All right, I don't have the offer on the calendar, so Ms. Tucker, if you'll give it to me slowly.
Yes, Judge, it's going to be 12 months to serve 34 days. Credit for time served 17 days. Balance probated. To complete the MHET, complete 8 weeks of anger management, and have no further violent contact with Brett, BRETT, BAFTA, BAFTA.
All right, is Brett BAFTA present and wishes to make a statement? And I'm sorry, Ms. Tucker, will you give me his history as well, in light of the
Yes.
MH request?
Yes, he's got quite a lengthy history. Trying to scroll to the bottom to give you the most recent first. So he's got 69 cycles. He was also charged with terroristic threats felony in this case, but the DA declined it. So he's just charged with simple battery now. Most recent arrest was a probation violation in Paulding County, September 2024. Probation violation, quite a few probation violations in September of 2024. Obstruction conviction and misdemeanor terroristic threats conviction, July 2024. Simple battery in a public transit car, as well as simple battery against public school employee, February 2024. More probation violations.
Okay, and this is the state's offer, even considering, I want to look at something myself.
Yes, considering the fact and our victim contact, this is the state's offer.
Okay, and the state has made contact with the victim, correct?
Correct. Yes, he says he has no opinion on bond. He says no contact order is not necessary. He just doesn't appreciate what happened to him.
Okay.
So we're offering no further violent contact, and the rest of the state's terms.
All right, Mr. White, was that your understanding and do you stipulate?
Yes, Your Honor, and we do stipulate the purpose of the plea. We would ask to waive the first 2 months of probation fees. Once he leaves Fulton County, it looks like he has a Newton County hold. So I'm not sure when he's going to be back out, and just ask that his probation go to non-reporting once he completes all his requirements.
All right, I'll waive 1 month of fees, Mr. White. He can go non-reporting once he's completed.
Thank you, Judge.
All right, if you wish to take a plea, Mr. Harris, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea today?
No,
Did anyone promise you anything in exchange?
no.
And you understand that taking a guilty plea, you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes,
And you fully understand the requirements of the sentence, including the anger management class, the evaluation, and the fact that you'll have no further violent contact with with Mr. BAFTA?
yes, ma'am.
And you understand that taking a guilty plea can affect other aspects of your life, such as probation, employment, or immigration?
Yes,
All right, as to the charge of simple battery, how do you plead?
guilty.
I accept your guilty plea. Is there anything additional from the state of defense?
No, Judge.
All right. Best of luck to you, Mr. Harris. This case is now closed.
Thank you, Your Honor.
That's 22, Mr. Dixon.
Okay, Mr. Henderson, your case is 26 CR 003142C. You're charged with criminal trespass and damage to property. I have this as a conflict case, is that correct?
That's my understanding, Judge, and I do not see Mr. Murphy.
I don't either.
He's not
Miss,
online. Yeah, he's gonna be coming shortly.
okay, so we can't do his yet. Let's come back to you, Mr. Henderson. We're waiting for your attorney, okay?
23, Mr. Kendrick, next.
I'm sorry, say that again, 23.
Yes, ma'am.
Okay. All right, your case is 26 CR 003163Y. You're charged with loitering and prowling. You understand your rights?
Yes, Your Honor.
All right, Ms. Tucker.
Be 12 months to serve 36 days, credit for time served 18 days, balance probated, to complete 40 hours community service, and to stay away from 855 Piedmont Avenue in Atlanta.
All right, that was your understanding, Mr. White. You so stipulate?
Yes, Your Honor, to both. We would just, again, we'd ask the probation to terminate once he completes his community service.
All right, it can terminate once completed. If you wish to take a plea today, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time that would affect your ability to understand this proceeding?
No, Your Honor.
Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange?
No.
And you understand that taking a guilty plea, you're giving up your right to trial by judge or jury?
Yes.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Mm-hmm. Yes.
All right, and you understand the requirements of the sentence, including the stay away from Piedmont Avenue and the community service?
Yes, ma'am.
And you're satisfied with Mr. White's representation?
Yes.
All right, as to the charge of loitering and prowling, how do you plead?
Guilty.
I accept your guilty plea. Best of luck to you. This case is now closed, all right?
Thank you.
All right, who do you have next?
24, Mr. Holman.
And Judge, Mr. Holman, actually, I'm not sure how we're proceeding. He wouldn't really engage me yesterday. I'm not sure even if the public defender's office is representing him.
Okay, so Mr. Hammond, what you wouldn't you won't allow Mr. White to help you, and I strongly suggest that. Your case is 26 CR 00316668. You're charged with criminal trespass. Do you understand your rights today?
I understand my rights.
All right, and I'm strongly suggesting you allow Mr. White, who is very skilled and knowledgeable, to assist you today. And you're rejecting his services?
No, I didn't reject the services. I attended the Air Force Academy Prep School in the year 2011.
Okay, I don't want you to say something too much because Ms. Tucker is listening, and you might say the wrong thing by mistake and end up with more charges. Okay, so I think you should speak to Mr. White briefly.
Right, right.
All right, I guess there's no other matters we can take while Mr. White is discussing.
Excuse me, Judge.
Yes.
You get a criminal trespass, they write out like a trespass, and then when you go back,
I can't give you any legal advice, Mr.
no,
Harlan.
I'm asking for legal advice. Let me ask you a question. They didn't give me a trespass, so when they approached me and said, "I'm arresting you for criminal trespass," and I'm asking, what is the trespassing that was written out? Because
Let me explain to her what you're asking, okay? Real quick.
No, I don't touch me.
Okay.
Right.
Yeah.
They right.
Okay, I think we're gonna waive arraignment on this case.
You just seen him touch me though. Right. So
Okay, I need you to relax, Mr. Holman. He's doing his best really to help you, okay? He really is.
I'm not on probation. I don't even supposed to be in the jail. So he not doing me a favor.
Judge,
Tell Pat the bad.
Please be quiet. Mr. Holman, calm down for a second.
I ain't no calm down. Y'all playing around for what?
No one is playing around, Mr. Holman. Mr. White, what were you saying?
His question to you is if you have. Let me finish. Let me explain to the judge.
I was born in Atlanta, Georgia.
Okay.
I'm not crying. I'm tired.
His question to you is he claims that he was not given a criminal trespass warning before he was arrested for criminal trespassing. He wants to know if we have the actual written warning. And I told him that's something that we probably don't have at this point. We would have to do that.
Right, we would have to go through discovery, Mr. Holman, and get prepared. Today is not about proving the existence of the evidence. Today is about, I'm assuming you do not wish to take a plea. Is that correct?
I don't know all the good Sean Corey Carter or Demetrius Miller.
I don't understand. Okay. Yes or no? Do you want to take a plea today to this matter, or do you wish for there to be discovery and more work done?
Oh, man, it don't matter. You don't got no trespassing written out. I'm not.
Okay. We're not talking about that. Okay, here are your options. Do you want to go to trial, Mr. Holman? Ms. Lewis, can you do me a favor? My Odyssey is not working here at home today. We're gonna arraign this case. Can you just send me the accusation, please? We're gonna arraign Mr. Holman and reset. Mr. Holman, what we're gonna do is sounds like there's some more development in your case.
I said I'm not guilty.
I understand, and we're going with that. And I'm gonna tell you all about your case, and we're gonna reset you for a trial date, okay?
No, I'm not going to.
Okay, that's what we're gonna set you to do because that is what not guilty means, okay?
Nah, matter of fact, what's on the paper, bro? Nah, y'all want to play that? Y'all want to play that way?
We're not playing anything, Mr. Holman.
I'll do probation for the criminal trespass.
Mr. Holman, you're not helping yourself. You really need to listen to me, Mr. Holman. Mr. Holman. Mr. Holman, do you hear me? You need to listen to me. You're not helping yourself right now. Please. Okay? Miss Lewis, can you send me that? All right, we're gonna arraign case 26 CR003168.
I feel like I'm being forced to, but I don't even care. I'm gonna accept what the public defender said. Don't touch me. I'm gonna accept what the public defender said. I'm not.
There's nobody who can waive arraignment, so I'm gonna have to arraign this case today, and then we're gonna reset for a division judge.
What you mean arraignment? What you mean?
I'm gonna tell you all about your case and tell you your rights.
Crazy, y'all live. But I just said I'm accept what he said, what the white man said.
Let's go, man. We done. Let's go, man. Come on.
Well, he's gotta stay for 1 second. I'm sorry. We gotta bring Mr. Holman back. Let me arraign his case very quickly.
Man, I'm talking.
Accusations on the way, Judge.
Thank you.
She said
What's her name?
the Judge Melanie Wood.
Right. So I'm gonna accept what she said.
He's done.
So what
She has-
what's the date? I'm saying, what's the date?
We can't waive arraignment.
What's the date?
We can't waive his arraignment because he's not, I have to arraign his case.
I understand, Judge. I think it's gonna have to be a reset at this point.
Yeah, he's too disruptive. I agree. Please put the notes in. He's got to be arraigned next week and brought to SAP. Okay, so we'll reset 6-9. Thank you, Ms. Lewis. Apologies to the jail. He needs to be, and please put the notes for whoever does the calendar that he must be arraigned at that time. All right, who do we have next?
Up at 22, Mr. Henderson.
Okay, Mr. Henderson, your case is 26 CR 003142C. You're charged with criminal trespass and damage to property. You understand your rights?
Yes, ma'am.
All right, thank
Morning,
you, Mr.
Judge.
Murphy. Good morning, Mr. Murphy. It's great to see you. What is the announcement for Mr. Henderson's case?
I had gotten the state's offer. I had yet to talk to Mr. Henderson. If the jail can call me, I'll be standing by. And the other case I had was Collins, which was transferred to the DA's office.
Okay,
But
so if we could have the jail give Mr. Murphy a call, please.
thank you. I've tried times I couldn't get a good signal, so now I'm near Mr. Jordan's office.
That's okay.
Thank you, Judge. And I'll have an announcement after I talk.
I'm going 25, Honeycutt.
And Judge, this is Latrell Honeycutt, position number 25. There is no offer from the state on this case based on the fact that they can't get in touch with the alleged victim. He's been reset now. The first time he was on this calendar was April 21st.
Okay.
A third of April all the way through May. Now we're into June. He would consider a plea offer. We do understand the reason that the state is not willing, not able to get in touch with his father is he's the complaining witness and does not want to prosecute the case. That's why he's not answering. But we would be asking that he be allowed to sign his own bond on this charge. At this point, he's now been in jail 62 days, I believe. And
what is the current bond?
It is a $2,000 bond set at SEA on the 6th of April.
Okay. Ms. Tucker, can I have, I'm sorry, Mr. Howard, can I have the history for number 25, Mr. Honeycutt?
I've got it ready, Judge.
All right, go ahead, Ms. Tucker.
29 cycles, relevant violent history. He's got 22 CR 001813J, a battery and cruelty to children. 22 CR 001814J, battery against a pregnant woman and a discharge of a firearm. That was transferred to Superior Court. He's got 23 SC 191316, aggravated assault reduced to battery in 2024. There's case 22 SC 181187, aggravated assault, possession of a firearm by a convicted felon, simple battery, family violence, as well as 23 191115, aggravated assault, possession of a firearm by a felon in 2024. We also show that he has a probation hold for Superior Court. So considering the violence in his history, yes, we have not had victim contact, and the state is, not comfortable, not able to make an offer without being able to discuss it with the victim per Marcy's law. So that's the state's position. And we believe that bond should remain as set considering the violent history and the violence alleged in these facts. In these facts, this defendant was being disrespectful to his mom. So the victim, his father, stepped in. He did slap and push his mom or push his father. And the mother is a victim in another case with him.
This is 1,000 each count?
Correct.
Okay. What I'm gonna do is I'm gonna send him, it'll be a $2,000 signature bond at level 2. through pretrial services per judge. I am gonna say that he needs to do at least 1 week of anger management as a condition for now, and then he'll be reset further notice. Objections, Mr. White?
None, Judge.
All right, and the same, what was it? No contact was on the original bond? I'm not gonna change whatever the contact was.
I'm not sure, Judge. I don't have that in front of me.
Give me 1 second, I'm about to tell you.
And he's fine with that, Judge. We discussed that
Yeah.
earlier.
All right, so no contact and stay away during the pendency of the case.
Thank you, Judge.
All right, we can keep going.
Judge, and that was pretrial 2 for 2,000 on each.
So 1,000 each. Okay, best of luck to you, Mr. Honeycutt. I'm letting you sign your bond, but there are
Judge.
conditions. You'll need to engage in that anger management course.
Excuse me, Judge. On the original bond, it had him to stay away, no further contact, and a one-time escort to retrieve items in a 24-week DVIP.
Oh, DVIP.
Mm-hmm.
Can you look at the chat, Ms. Lewis?
Judge, he doesn't need the escort. He doesn't need to go back to the house. He informs me.
I'm gonna let it stay at the 1 week anger management for now, and then I've adjusted the bond based on the time he's been in jail. All right, all right. Best of luck to you, sir. For now, who do we have next?
26, Mr. Hope.
All right, and this one is a negotiated plea.
Yes, it is, Judge.
All right, Mr. Hope, you have this case for 26 CR 003176L. You're charged with failure to obey signs, failure to have your license, driving while your license is suspended, obstruction, and a seatbelt violation. Ms. Tucker?
Yes, on the failure to obey, that's going to be 12 months to serve 34 days, credit for time served 17 days, balance probated, to pay a $150 fine. The no license charge will merge into the suspended license, that's count 3, with the terms 12 months to serve 34 days, credit for time served 17 days, balance probated, with a $500 fine. On the obstruction, it'll be 12 months, served 34 days, credit for time served 17 days, balance probated, with a $300 fine, and the seatbelt charge is just time served.
All right, that was your understanding, Mr. White, and you so stipulate.
Judge, 1 second, please.
I think we lost him, Judge.
I think we did too. I was hoping they come right back.
And Judge, I believe the last question was if that's what we understood in stipulation, and we do stipulate, and that's our understanding. A couple of requests. We would have to enter a NOLO on the suspended license charge, and we'd like to convert all of his fines, I believe, comes to 95 hours of community service and waive the first 2 months of probation fees. He does have a couple of holds in other counties after he gets here, so it may be a while before he's earning it.
Okay, I'll waive 1 month of fees. Any objection to the NOLO, Ms. Tucker?
He qualifies, so
All
no
right.
objection.
All right, Mr. Hope, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge? All right. Are you under the influence of any, you can put your hand down, thank you. Are you under the influence of any drugs or alcohol that would affect your ability to understand this plea? Did anyone promise you anything in exchange for taking the plea?
No, ma'am.
You understand you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you're giving up your right to have state prove these charges against you beyond reasonable doubt?
Yes, ma'am.
And you fully understand the requirements of the sentence, including the community service?
I do.
And you understand that taking a guilty plea can affect other aspects of your life?
Yes.
All right. As to the charges previously listed, how do you plead, Mr. Hope?
Be guilty.
I accept your guilty plea. Is there anything additional from state or defense?
I thought it was a NOLO.
I'm sorry. I accept your NOLO plea.
It's NOLO on all charges, right?
You're pleading NOLO, correct?
Yes, Judge.
All right. I accept your NOLO plea at this time. Best of luck to you, Mr. Hope.
Thank you, Judge Williams.
Thank you, Your
All
Honor.
right. Have a good day. Who do we have next?
Don't come back.
We have position number 27, Mr. Hudson.
And we don't have an offer for Mr. Hudson.
Correct. We have had no victim contact.
Do you want to be heard on bond, Mr. White?
Judge, yes, he has been in since the 18th. And his bond currently is only $1,000, so.
Okay.
And we would just ask that it remain as set. He does have a few violent convictions, 2025 a simple battery conviction, 2025 criminal trespass conviction, 2025 simple assault guilty conviction. So all very recent history. He also had a 2013 battery family violence. That was amended to disorderly conduct and convicted. The facts of this case allege that video footage showed the defendant striking the victim multiple times with closed fists, leaving bruising and bleeding from his nose. So considering this, without victim contact, we just can't make an offer on this case. I think $1,000 good bond is very reasonable, especially considering his risk of reoffense with all those recent convictions. So we would ask the bond remain as set.
I'm not gonna change his bond at this time, Mr. White, but I mean, if there's something you'd like to tell, I'll listen. Go ahead, Mr. White.
I understand, and I explained to him that he's only been in a couple of weeks at this point, and so the state's likely to get a week or two. But we would still request a signature bond at this point. He is missing work, and he has a child that he pays child support on, and he's not getting those payments. So.
There's also on his bond, they gave him the opportunity to go through the 10% program for the sheriff.
Oh, he did receive the 10%?
That was one of it's either or. He can make the surety or go through the 10% program
So
through the sheriff.
were you
either
aware
or.
he had the 10% option, Mr. White?
I wasn't, Judge. I wasn't at his first appearance, obviously.
Okay, so that I'm definitely not gonna modify it in light of the fact that he has that option. Okay, thank you, Ms. Lewis. All right, best of luck to you, Mr. Hudson. I think should we reset SAP just to see if your office does get in touch, Ms. Tucker?
Yes, we're making all best efforts. So
Okay.
once we exhaust all efforts, which includes going to the victim's home, then we will make an offer.
All right, let's reset SAP at least till next Thursday.
Can we do it next Tuesday, Judge?
I was trying to give the state a little bit more time. Because the problem is that, if our problem is they got to go to somebody's house, I was trying to give them at least till next Thursday to do so.
Fair enough.
Okay.
That'll be 6/11.
Okay.
That'll be 6/11.
I'm sorry, Mr. White, go ahead.
I'm just trying to ask Ms. Tucker while thinking about it. If you could just make a note when you don't make an offer on a case, that's the reason, because sometimes we're thinking that it may come. I get it.
Okay, I got you.
Thank you.
All right, sir, we'll see you next week. Mr. Murphy, you have an announcement?
Yes, Judge, I conveyed the order, and we're going to decline that And we'll just look to send that case to the judge.
Okay, so all right, so your attorney has some additional development on this matter, and we won't be doing anything today. He will be in touch with you between now and then, to continue the development of your case. All right, Mr. Henderson?
Yes.
All right, take care. Have a good afternoon. And Mr.
Right.
Murphy, does that conclude your business
That's all.
today?
Yes, the other case I had was Collins number 8, and that was transferred to the DA.
I can't breathe.
Okay, all right then, Mr. Murphy, take care. Have a good day.
Judge.
All right, going 29 law.
Okay. This is a plea.
No, Your Honor, Mr. Lawson is entering a not guilty.
All right, Mr. Lawson, again, you have their case is 26 CR 003159B. Your attorney is gonna do some more development on this case. So we'll be resetting it. I'm sure they will be in touch with you between now and then as the case progresses, okay?
You know, how many more weeks they got?
I'm sorry.
How many more weeks they got?
Oh, you're gonna be set as if you're going to trial and your attorney's gonna keep working on your case, okay? But you do have a bond at this time, okay?
Yeah.
All right. If you want to ask your attorney, Mr. Judge, some questions, this might be a good time. But other than that, your case will be addressed at a later date.
Thank you, Your Honor.
All right, thank you. All right, are we complete? No. What about number 11?
Your Honor,
It's muted.
you don't know what Mr. Dillard, he
Yeah.
actually his mind this morning and will be entering a waiver.
Okay, thank you. All right, Ms. Lewis, have we done the whole SAP calendar? Have I missed anything?
What was that announcement on number 11?
That he's gonna waive arraignment.
Oh, okay. Sounds about it. Okay.
I think that's everybody. I know we have an 11 o'clock calendar, but let's
Yeah, we just go through it right quick.
all right, we're gonna review our SAP calendar. Thank you, Ms. Lewis.
You're welcome. Can everybody hear me? Okay. Position number 1 and 2 are waive arraignment, we set for trial per the notice. Position 3 and 4 was released. we set
Excuse
for
me.
the notice. Yes, sir.
Is she not doing my case today?
And who is your case, sir?
Xavier Brunson.
Are you on the 11 o'clock calendar, sir?
No, man, I was on the 9 o'clock calendar.
Hold up. He may have, was you recently incarcerated and was released, sir?
You're not on this calendar.
The
It was
11
from
o'clock.
last year. From last year.
Okay, sir, just let Ms. Lewis do what she's doing. We'll come back to you in a moment, okay? Please continue, Ms.
Yes, ma'am.
Lewis.
Okay. Thank you, Jay. Okay, position number 5 was a plea. Position number 6 is waive arraignment, we set for trial further notice. Position number 7 was a plea. Position number 8 was transferred to Superior Court. Position number 9 was a plea. Position number 10 was a plea. Position number 11, waive arraignment, reset for trial further notice. Position number 12 is reset for the SAP 6-9. Position number 13, reset for SAP 6-18. Position 14, waive arraignment, let's go for 14, 15, 16, 17, all waive arraignment. Position number 18, same announcement, waive arraignment along with position number 19. Position number 20 was a plea. Position 21, waive arraignment, reset for trial further notice. Same announcement for 22, waive arraignment, reset for trial further notice. Position 23 was a plea. Position 24 is reset for SAP to be arraigned for June the 9th. Position 25 is reset further notice, amended bond order to a $2,000 SOB through pretrial level 2 with 1 week of anger management class and no further contact with the victim and a stay away and one-time return to retrieve personal items. Position number 26 was a no-load plea. Position 27 is reset to next Thursday, June 11th, SAP. Position 28 was a plea. Position 29, waive arraignment, reset for trial, further notice. Position 30 is reset for SAP for 6/9. Position 31 was a plea. Position 32, defendant was released, reset further notice. Position 33 is reset for SAP 6/9. Position 34 was a plea. Position 35, waive arraignment, reset for trial, further notice. Position 36 is a non-pros. Position 37, waive arraignment, reset for trial, further notice. Position 38 is waive arraignment, reset for trial, further notice. 39 is amended bond order to a $6,000 surety. Position 40, reset for SAP 6/9 pending transfer. Position 41, waive arraignment, reset for trial, further notice. Position 42 was a plea. Position 43 was a plea. Position 44 was a plea. Position 45 and 45 is waive arraignment, reset for trial, further notice, along with 46 and 47 and 48 and 49 and 50 and 51 and 52. All those are waive arraignment, reset for trial, further notice. Position 53 was a plea. Position 54 was a plea. Position 55 was a plea along with the additional case number 25 CR 004281G. Also enter a plea on that case. Position 56 was a plea. Position 57, waive arraignment, reset for trial, further notice. Position 58 was a plea. And I think that take care of the calendar. Any questions or corrections?
Mr. Brinson is on the 11 o'clock calendar, so sir, please hold. All right, any other comments, changes, corrections, or questions?
Who should I send null pros to?
Me, Miss Katrina.
Got it.
Hey, Judge, can I ask you a question?
No. Just please hold 1 second. All right, Ms. Lewis, any, okay, I'm sorry, Mr. White, you started to say something?
No, I was asking my colleagues. Am I not
Okay.
muted?
Are you covering the 11 o'clock calendar?
I certainly can. We just have the one, is that correct?
Yes, this is DV bench warrant, so there may be some parties that need to speak to you. I think Mr. Brinson may be one of them. Okay, Mr. Williams, what is your question?
Yes, ma'am. I'm sorry to disrupt y'all. I missed the case of Tanisha Norris. I needed to see what was her position and what she stand on.
I don't see that on the, oh, that case will not be addressed today. It's gonna be taken up at a later date. What you should probably do is give the public defender's office a call if you, or if, are you the alleged victim in this case?
Yes,
If
ma'am.
if a victim witness advocate, maybe somebody from your office, Ms. Tucker, could speak with him. He's the victim for position 37.
Okay.
All right, we're gonna take, we don't really have that much time to take a break. It's 11 o'clock. It's time for us to commence the DV bench warrant calendar. I'm gonna call and make sure everybody's here. Mr. Brinson, we've seen. Is there a Kawani Ragland? Is Kawani Ragland present?
Yes, I see her on the line. Asked them to start the camera.
All right. Is there a Sheila Rosser? I haven't seen one of these. I cannot hear. Is it the young lady that says Samsung? Are you Miss Rosser?
Yes, ma'am.
All right, let's make arrangements for you both to speak with Mr. White, and we'll come back in a few moments. All right, we're gonna be on a very brief hold.
Yes, ma'am.
I believe position one, Mr. Brinson has private attorney. I do not recognize that name.
All right, Mr. Brinson, you have an attorney?
That's from the PD office.
Oh, it is? Okay. I don't know. All right, we'll
See
take
the
that.
name? Alviz? Okay. All right, so if you'll speak to them, Mr. White, thank you so much.
And can I get them one at a time in a breakout room?
Yeah,
Yes, sir.
Miss Grace can do
We'll
that.
start with Mr. Bradford.
I'm Keywan Ragland. I'm here. I can't figure out how to turn the camera on.
You need to be able to get your camera on, Mr. Ragland.
We need more. All right.
What's getting ready to happen now is the host is getting ready to put y'all in an individual break room with the PD, so accept it.
How do you
One by one. It's gonna prompt you later on. Once he come out with the first one, then you will be next, ma'am.
Okay, thank you.
It's one at a time.
Yes.
Mr. Ragland, you need to try to get your camera on, please.
Exactly.
The camera, is it on?
Yes, sir, I can see you. You're
Okay,
good.
okay,
Okay. What's gonna happen now is that once the public defender, Mr. White, comes out of the breakout room, then one of you all will be next to go in. We're just going by the counter. So Miss
okay.
Grace will put you in a breakout room next, and then Miss Rosser, you will be next on the counter after that. So just stay tight and keep your camera on. When that prompt comes up, accept it, and then you'll go into the breakout room. And then once you're done, you should be able to come out.
Okay.
Good morning, Miss Manning.
whoever the tech genie is, could I now have a breakout with Mr. Ragland?
Miss Grace, she's gonna put the next one in.
Thank you.
Mm-hmm.
Mr. Ragland right here.
They're gonna put you in a breakout room. We'll talk in a second.
Okay.
All right, Miss Ross, you're next. They're gonna put you in a breakout room. Miss Ross, look at your phone. There should be something down there that say accept to go into a breakout room. Accept the invite to go to the breakout room.
Judge, we're ready whenever.
I'm ready. Yep, I'm ready. All right, let's commence Mr. Brinson, case 25 CR 0023488H. This is the DV bench warrant calendar. Mr. Brinson, we'll need you to turn your camera on. This calendar is for those who fail to appear and they have a current DV bench warrant case. I'm going to listen to the state and then I'm going to hear from the attorney as to whether the party will be required to surrender themselves to the Fulton County Jail within 72 hours or whether we will lift the bench warrant. Mr. Brinson apparently missed a jury trial calendar before Judge Taylor on December the 1st of 2025. Ms. Tucker?
Yes, Judge, I do see that is the first time that he missed anything on this calendar. It looks like he already had the public defender representing him, so I don't see any reason why he would have missed.
Okay. Mr. White?
He was actually called by the public defender that I don't know, it sounds like a calendar call, and not to come until he was contacted by his public defender. He didn't hear from him. I'm not sure what happened, but as you heard, this is the first time he has missed. He's not trying to miss court. He was all the way to the trial aspect, and he would like to get this resolved. So we just have to set aside the bench warrant.
So he made it all the way through to the jury trial calendar. The public defender was present and there was some miscommunication there.
Apparently, he was told to come to court unless contacted by his public defender.
Okay, well now he understands that's incorrect, right?
Yes.
All right, Mr. Brinson, I will dismiss it this one time. You get a one time only because you did appear at all the other calendars. However, you are responsible for showing up at every single other court date. You will not get another dismissal for this reason in this type of case, okay?
Yes.
So you need to check on your case, if not of every other week, at least monthly. And if there is a matter pending, whether or not your public defender has told you, you need to plan to be there, okay?
Yes.
All right, you're free to go at this time, Mr. Brinson.
Will I be notified about my next court date?
You better call down to the clerk's office and figure it out yourself, okay?
And just be mindful that it takes 24 to 48 hours for the warrant to be dismissed.
I've explained that to all of them. You should get notice in the mail, but like I told you before, check the website, call the clerk's office, do all those things to.
Because you missed one time, you won't get another one, okay?
All right, thank you.
All right, you're free to go. All right, let's call the case of Mr. Ragland, 25 CR 0072111. I'm sorry, 11E. He missed a plea and arraignment before Judge Morrison on the 15th of May. We're gonna listen again to see whether the bench warrant will be set aside or whether you're gonna be required to surrender yourself to the Fulton County Jail. Ms. Tucker?
Yes, Judge, we would ask that it remain as set. He was released on a very high bond, on a $17,000 split bond, so he should have, taken it very seriously and come back to court. And I don't see a return of service, so I don't see any reason why he wasn't in court.
Okay, Mr. White?
Judge, he moved in the interim and failed to change his address. He has since done so. He found out that he missed through his bonding company. And as soon as he did, he went down and changed his address. This is the first time he's missed court. Why he should be treated any differently than anybody else. I explained to him that if he does again move, it is his responsibility to physically go to the courthouse and change his address there, not just with the Postal Service. Additionally, I also told him about checking the website and calling the clerk's office. We just asked you to set aside the bench warrant.
All right, I'll set it aside this one time, Mr. Ragland. You are getting a second opportunity. Most judges would not reset it for similar reasons. However, again, this is your one and only reset. Make sure that you are responsible for monitoring your own case, not the public defender, not anyone else but you. You need to update your address and check on this case every other week, okay?
Yes, ma'am.
All right, you're free to go.
Thank you. Y'all have a good day.
All right, now we're gonna commence Ms. Rosser's case 24 CR 0011768. She missed, we've already had one set aside by Judge Law, and then she missed a jury trial calendar call on November this 20th of 2025. Ms. Tucker?
Yes, Judge. As you said, she's already got the, one forgiveness. And she still failed to appear. And a fail to appear for jury trial is a big deal because we subpoena witnesses, we subpoena officers. It takes a lot on the state. So considering she's already got her one forgiveness, we would ask that the bench warrant remain as set.
All right. Mr. White, this one is a little different from the other two because she did have a recent one set aside previously on this case.
When was that, Judge?
It was in I'm sorry, hold on, let me look again. Ms. Lewis, can you help me? When was
It was
it?
on September the 5th. September the 5th by
So she missed like
2024 by
essentially
Judge Law.
so essentially she missed the first one and ended up on this calendar, and then she missed this last one. Okay, so Mr. White?
September the 5th, is that what I heard? Everybody's cross talking. I could.
Yeah, September 5th, 2024. She was on this calendar before, this same DB bench warrant calendar.
For this case.
Yes.
Judge, she didn't receive notice. We're not sure exactly why. She also says that she may have been in the hospital. She did spend some time in the hospital since this. She doesn't know exactly what date she missed. And I'm sorry, you did say that. What was the date that she missed this time?
She missed November the 20th of 2025. She missed the jury trial calendar call, and she had also missed the very first court date where she would have been warned by Judge Law about the plea and arraignment.
Judge, she does have some MH issues and some physical issues that and she's also the caretaker for somebody that's very ill. We would just ask to give her one last chance. This case has been going on since it was accused March 11th, 2024. So over 2 years now. She would have had several court dates in the interim that she did not miss. I understand that she did miss one back in September. She did not intentionally do that. I've also given her the speech about checking the Fulton County website and calling the clerk's office. I think it would be an incredible hardship for her to turn herself in and make a new bond.
1 second, Ms. Lewis, look at your chat real quick. Okay. 1 second. Thank you, Ms. Lewis. All right. I will say that she will not get another chance. This is, I'm pushing the bounds of what I normally do. Ms. Rosser, the next time you will be required to surrender yourself to the Fulton County Jail. You are responsible for monitoring your own cases. No one else is going to do that for you. If you miss another court date, you will be required to surrender yourself. I will set the bench warrant aside this one time, all right? All right, we have concluded the DV bench warrant calendar. Is there anything additional from anyone else before we adjourn? Ms. Lewis, I'm coming down to G33 in about an hour if you want to bring those rather than having to stand and scan. Okay? All right. I think we can be in recess. Take care, everyone, and have a good afternoon.
Thank you.
All right, bye-bye.
Was there a law passed? Why?